So welcome to our Data Practices Potpourri webinar for January. Thanks for joining us. For those of you who aren't familiar, the Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. We also help the Commissioner of Administration with issuing advisory opinions and provide legislative assistance and training. Our webinars are recorded, so if you miss part of today's webinar or you want to go back and watch one of our prior series or share one with a friend, they're posted on the Data Practices Office YouTube page. So I'm going to show you how to find those videos on our website, which is linked on the slide. Okay, I'm just sharing my browser with you now. So on our website, if you scroll to the bottom, you can click the YouTube icon that's at the bottom of the page, or you can go to our news and events, webinars, and on our webinars page, we have a link to our YouTube channel. So I'm going to go ahead and click this. While you're here on this page, though, we do have some audio FAQs if you're ever having issues with your audio during one of our webinars. Okay, so this is our YouTube page. And on our YouTube page, you can see our playlists, which have our different series, or we just have quite a few different videos on different topics like social media or what all employees need to know. So this would be the place to go. All right. I am going to go ahead and share a copy of our PowerPoint right now before we get started. Okay, so you should see a pop-up on your screen where you can download today's PowerPoint. If you miss it or you're not able to download it right now, we do upload all of the PowerPoints for our webinars to that webinar page on our website as well. And so that's available for you if you want to download the PowerPoint later or you forget to save it. I'll also put the PowerPoint up again for download later in the webinar. So today is the third installment of the Data Practices Potpourri series, which will be an opportunity to hear what issues data requesters and government entities are encountering this month. As usual, we'll leave some time for questions during our Q&A session at the end of the webinar, so feel free to send in your questions as you think of them using the Q&A panel on your screen. When you send in the questions, please send them to all panelists so we can be sure to see them. All right, so we're going to get started with question number 1. A military recruiter contacted a police department with a request for records on a specific individual. The police department has juvenile drug citation records that are responsive to the request. Can the police department give the recruiter the records? So peace officer records on juveniles who are or may be delinquent are classified as private under Minnesota Statute 260B171, and that's subject to a few exceptions. But due to this private classification of juvenile data, juvenile delinquent data, you can only provide access to the private data to the data subject or those who have been authorized by the data subject through informed consent. Minnesota Rules 1205.1400 subpart 4, that's listed on the screen there for you. That requires that a valid informed consent must be voluntary and not coerced. It has to be in writing, and it has to explain why the release or a new use is necessary. The informed consent also has to include any known consequences for giving the informed consent. If the individual is a minor, so if the data on the juvenile delinquent, if the individual is still a juvenile or has a legally appointed guardian, the entity might also need the signature of the individual's parent or guardian, depending on the situation or the entity's policy. So if you're interested in a more detailed review of data on juvenile delinquents or law enforcement records on juveniles, I would review the 4th webinar in our law enforcement series on our YouTube page. That walks through law enforcement records on children and specifically these types of records if you want more information on that. Okay. Question number 2, a member of the public submits a complaint to the Department of Administration about a government employee. The department investigates the complaint and determines discipline is not warranted. A member of the media makes a data request for all investigated data. What may the department release? So with government employees, we look to Minnesota Statute Section 1343, which reverses that public presumption and indicates that all data on government employees are private, unless specifically called out as public. So much of the public data about government employees are listed in Subdivision 2 of 1343. And Subdivision 2 outlines what becomes public during various stages of discipline and complaints against government employees. When an employee is not a public official and a complaint does not result in discipline, the only public data about the action are existence and status of the complaint. So the department may indicate that a complaint exists here and it is closed with no discipline. That would be the existence and the status. There is this Navarre case, which is cited on the slide for you. And it discusses existence and status in greater detail. So this case emphasizes that 1343 only authorizes the disclosure of existence and status of complaints prior to final disposition of discipline, and that the type of complaint can't be disclosed. It also discusses specific language that might reveal more information than appropriate when discussing existence and status. So that can be a helpful case to look at if you have a question about what existence and status means. So just to follow up to that question, what data are public if the employee is disciplined and the discipline is final? So if the employee is disciplined, much more data become public. The requester would receive the final disposition of the discipline, so the discipline that was imposed, along with the specific reasons for the discipline and the data documenting the basis for the discipline. So something for government entities to remember here is that there could be multiple data subjects in some of the data that document the basis for discipline. And some of those identities might be other government employees, and identity can be more than just a name. So when releasing disciplinary data under this section, the entity will need to ensure that it's sufficiently protecting the identities of other government employees while providing necessary access to the public data of the disciplined employee. Okay, question number 3. So we're building off of employee discipline. We received some questions this past month on what becomes public when employees grieve discipline through the arbitration process and what happens depending on whether the grievance is upheld. So question number 3 is, if a government employee is terminated for a violation of Rule A, the termination is grieved through that arbitration process, and the arbitration issues a final award reinstating the employee. With the suspension, so instead of a termination for a violation of Rule A, is the original disciplinary action public? So this question can be answered by the plain language in Minnesota Statute Section 1343, Subdivision 2A5, which is on the slide there for you. That section states, final disposition of any disciplinary action together with the specific reasons for the action and data documenting the basis of the action are public. These are the specific data elements that become public when discipline has occurred. So when a public employee grieves disciplinary action through that arbitration process, the discipline is not considered final until the grievance process is complete. In evaluating the classification of this data, the government entity first needs to determine the final disposition of any disciplinary action, which appears to be the suspension, since that was the discipline that was upheld after the employee grieved the disciplinary action, so rather than the termination. Then the entity will need to determine the specific reasons for the suspension and the data that document the basis for the suspension. So these are the data that would become public. It's unlikely that that initial termination would be considered a specific reason for the suspension, or that the termination would be data that document the basis of the suspension. Instead, that underlying conduct or violation of Rule A would likely be the specific reason or data documenting the basis of the action. So here, the termination is likely private personnel data because it's discipline that did not ultimately occur. So here's a little twist on that last question. If a government employee is terminated for a violation of Rule A, the termination is grieved to the arbitration process, and the arbitration issues a final award, reinstating the employee with suspension for violation of Rule B. So the employee was suspended for Rule B instead of terminated for Rule A. What data would be public here? So we have Advisory Opinion 17-009 that addresses this issue. If the employee was ultimately not disciplined for a Rule A violation, then the data about that Rule A violation are private personnel data. Since the employee was disciplined for violating Rule B, the final disciplinary action, which would be the suspension, together with the specific reasons for and the data documenting the basis of the suspension for violating Rule B, are what would become public here. Okay. Question number 5. Are the legislature and judicial branches obligated to respond to data requests? No. So the legislature and the courts are not subject to the Data Practices Act. Currently, only the Minnesota executive branch government entities, such as the state agencies, statewide systems, political subdivisions like cities and counties, are subject to the Data Practices Act. However, the judicial branch, it does have its own court records access procedures, and so you can contact the courts to determine whether you can access certain data that you're looking for, but the Data Practices Act doesn't apply to them. And then as for the legislature, they get to decide what information they provide in response to any requests. Question number 6. Do meeting minutes satisfy the journal votes requirement in the open meeting law? So in a recent advisory opinion, which is 21-001, it's on the slide there, the commissioner addresses this issue. In reaching her conclusion, she discusses both the plain language of the open meeting law as well as the Attorney General's opinion from 1975, which is cited on our website. So meeting minutes don't satisfy the journal of votes requirement. Public bodies must maintain a journal of votes documenting the votes of each member of the public body on any action, except for payments of judgments, claims, and amounts fixed by statute. And that exception is listed in 13D01 subdivision 4A. Okay, so those are some of our top questions this month. I'm going to put up the PowerPoint again, and we're going to start answering some of the questions that you all have. So if you haven't already, please feel free to put those questions in the Q&A panel to all panelists. And if we don't get to your question during the webinar, we'll follow up with you afterwards. Okay, so you should have the pop-up coming up with our PowerPoint, and we'll start looking into your questions.
Okay, if you hear a little silence here, it's just us taking a look at your questions. One question is, what exactly is a journal of votes? Well, that's a good question. The requirement is that there is a journal in which that opinion from 2000 that was just issued talks about the need to have some sort of ledger or log that identifies the item that was voted on and then how each member voted. And so however that looks to each public body, that's up to you to determine.
Okay, here's a question. Is a 911 call able to be released to another individual, not the caller? If not, can the person get a transcript of the 911 call? So under 1382, a 911 audio are actually classified as private data on the caller. So the requester can't get a copy of the audio unless they have informed consent of the data subject. But that section also requires that law enforcement provide a transcript of the 911 call in lieu of the actual audio recording. Here's a question on the Journal of Votes. Does it need to be made available publicly, or does it just need to be provided upon request? Under Minnesota Statute 13D.01, Subdivision 5, the statute addresses public access to the journal and indicates that the journal must be open to the public during all normal business hours where the records of the public body are kept.
Okay, we have a question about licensing data, and it's a question about what is the classification of licensing data, for instance, on a peace officer from the Board of Peace Officer Standards and Training. Is it public or private at the employer charter city? So Section 1341 classifies licensing data at the state agency that is the licensing board. So here the Board of Peace Officer Standards and Training. 1341 classifies that data there. Once a public entity employer has that data, it becomes personnel data. So you just need to look through Section 1343 Subdivision 2 to determine whether there are any public elements in that data or whether it falls under Subdivision 4, makes that information private. We have a question about audio recordings related to interviews, maybe in a police investigative file. So is an audio recording of an interview involving people other than a data subject public data? For example, if multiple witnesses are being interviewed as part of a police investigative file and there are audio recordings, can anyone request that? The answer depends on where the law enforcement agency is in their investigation. If the investigation is active, largely those interviews would probably be confidential or protected non-public under 1382 subdivision 7. Once the investigation becomes inactive, subject to a couple exceptions, those interviews would become public, and then the public would be able to access those. Question about data breaches. If there's a data breach and a government office maintains a list of items, let's see, did we cover that one already? It will depend on the classification of the underlying data and whether that list identifies any private data.
Okay, here's a question. If a public body meets via video conference, is it okay to only have a call-in, no video option for the public? So when you're holding remote meetings virtually under 13D021, it just talks about electronic monitoring. It doesn't say how you have to provide electronic monitoring, but a call could work. Audio or visual could work, but they at least need to be able to hear the discussion that's there.
We have another question. We have a question about body-worn camera video. When we have to redact a body-worn camera to blur the image of a data subject who has not consented to the release, do we also have to redact their voice? So in section 13.825, that section classifies portable recording systems data, which we more commonly refer to as body camera data or body camera video. It says that the video is, that the data are both audio and visual, and so that redact means to blur the video or distort audio so that the identity of the subject is sufficiently obscured. So it does say blur video or distort audio, so it will depend on whether you find that the audio is also identifying to that particular individual.
Okay, here's a question. We received a request for a criminal sexual conduct case from the suspect. So the suspect was requesting data. The case is not charged. It says the agency had received a notification letter from the BCA that they had destroyed the arrest data and the suspect name, fingerprints had been destroyed. How do you handle the request? So I think we need a little bit more information to give specific guidance on this one, but generally, there are protected identities in criminal sexual conduct cases, including the victim of criminal sexual conduct. So the victim's identity would need to be protected. As far as the suspect, I don't know what type of law enforcement agency or what sort of agency has this data, but you know, if you have law enforcement data that's available to the subject, you need to provide them all public data and then redact out any protected identities. If you want to give us a call, I'd be happy to talk about it further.
There is a question asking, has any COVID-related data practices legislation been introduced this year? Do you expect any big data practices legislative discussions? So far, I haven't seen anything come through or be proposed related to the emergency or the COVID emergency that we're in right now. So I'm not sure about that. Any big data practices legislative discussions? Again, interestingly, a lot of the legislative discussions have been centered around the open meeting law. Most recently, but it's early days yet with the legislative session. Okay, we're just waiting on a few more questions. If anybody else has any questions, please send them in. If we have not gotten to yours yet, we will follow up with you. We got quite a few, and I'm just trying to make sure that we have seen all of them. We are going to launch a poll right now, which is our evaluation. If you could please fill that out, we would appreciate it. While we're waiting for more questions to come in, you could fill out that poll and let us know how we did, and also if you have any other suggestions for topics that we could cover in these lunchtime webinars. So we have a question about surveys or interviews. A consultant will conduct interviews with city staff and residents. The consultant will have the identifying data, and the city will receive aggregate data. Will the consultant need to release data if requested? So under Section 1305, Subdivision 11, if government contracts with a private entity to perform a government function, then that private entity here, the consultant, is subject to the Data Practices Act to the extent of that contract. So whether it's available to the public is one of those, it depends. The data on the public, unless the city here has a specific classification related to the data on the public members, would probably just be presumptively public. In terms of the data that the city is going to maintain about, city staff, some of that might fall under Section 1343, Subdivision 7A, which is called Employee Suggestion Data. So you want to take a look at 1343, Subdivision 7A. If you are asking for any private data from the city staff, then yes, you would need to provide a Tennyson warning. Again, if the data are public on the city residents, then you don't need to provide a Tennyson warning. And we have a question about body camera video. It says, if body camera video is presented in court, is it then considered public data, or is it always considered private for the data subjects? So 13.825, again, the body camera data statute says that active criminal investigative data are classified by 1382. So then we go into Section 1382, and Subdivision 7 says that active criminal investigative data is confidential or protected non-public, and then it has a provision that says until or unless when it's presented in court, then it becomes public. So I think it's reasonable to say that if body camera video is presented in court, it does become public. And also, if there are some concerns around that, then government or parties can have a discussion with the judge about whether a protective order is appropriate at that time.
Here's another question. If someone is submitting public data, then we don't need to provide a Tennyson warning. So they're asking whether if you're collecting public data from individuals, you don't need to provide a Tennyson warning. Tennyson warnings are only when government entity is collecting private or confidential information from an individual about that individual. Okay, so we are actually at time today, but there are a few questions that just came in that we haven't gotten to, so we'll be reaching out to you individually to follow up and give you some answers for those. Thank you all for joining us today. Stay tuned for our Gov Delivery notice for our next webinar. For those of you who are interested, we're hosting a full-day personnel workshop on February 10th. It's a paid workshop, and registration information is available on the workshop page of our website if you would like, or anyone in your entity would like, a full-day training on personnel data. If you have any requests for certain data practices or open meeting law topics that you'd like us to cover in a webinar, please let us know and we can hopefully incorporate that. Thank you.